What I've done is, this is our opinion, just few of the important pages alone, my lords, I've put together with headings so that it will be easier to quickly run through. Can I just give a copy? Give them a copy. Given, no? Yeah. Yes. Voice complaints. Voice complaints. Voice complaints. That was on Thursday. My lords, I heard it on Thursday. Yes. Thursday. It was heard on Thursday. For the notes to be.
I don't know the notes.
It's all in the mind.
No. I told my Lalit brother that he will have to write so.
This weekend occupation. I said just keeping the weekend occupied.
Now, let's see, other day, so sorry. My lords will recall.
You are audible.
No, because the papers are being taken up. Yes. The other day, my lords will recall, I had pointed out 2-3 things. One, my lords, really, as I was saying right at the outset the other day also, my lords, the nitty-gritty of how this is being used, what really is, my lords, the problem with what they are doing, what is the issue with the regularization application, all that the MCD has to handle. As Amicus, I'm really focusing on only 2 larger things, my lords, because this kind of a claim is symptomatic of various shops in some markets all over Delhi, 7, 8, 9 markets. Such a claim was made on an earlier occasion, rejected by my lords. Then the matter went before the Judicial Committee. Judicial Committee gave relief in their favor. Matter came before my lords, where I pointed out one order of my lords of May of 2024, August of 2024. My lord said, no, this kind of a broad brush order cannot be done. In fact, there were elaborate arguments made at that time.
Let us see that order again.
Yes, now please come to page, show me the page in that. It's there in the compilation. Page 32, my lords. 16.
32 of the IA.
32 of just what I handed out now, my lords. Starts at 16, my lords. Starts at 16. It's order of 22/8/2024. My lords got that. At 27, my lords. My lords have that.
Yes.
In re order dated 18th December 2023, passed by the Judicial Committee. May I just place that, my lords? We have perused the order dated 18 December 23, passed by the Judicial Committee, constituted under the orders of this court. My lord, this is Vinod Chandran has page 27, my lords. Internal page 12, page 27, my lords.
Yes. Yes.
What I was placing the other day, the same order. We have perused the order dated 18 December 23, passed by the Judicial Committee, constituted under the orders of this court. The committee has dealt with basement, first floor and second floor of the buildings in 7 markets, which are more particularly described in para 2 of the said order. There is a challenge to the order dated 18 December 23 by the Municipal Corporation of Delhi, which is IA 32418. Just make a note of this, my lords. This IA has been all placed before the lords now because MCD made a request. There are interlocutory applications filed by market committees and market associations seeking implementation of the said order, which directs de-sealing of the premises. Prima facie, we find after perusal of the said order that the committee has not looked into individual cases of building stroke units. Perhaps it was necessary for the committee to call upon the applicants to produce copies of sanctioned plans in respect of individual buildings and units and copies of documents of acquisition, allotment, purchase. We therefore permit filing of fresh applications in respect of individual buildings and units seeking relief of de-sealing. Needless to add that a copy of the relevant sanction plan and of permission granted by the local authority, document showing acquisition, allotment and purchase of premises in the building, and a copy of the layout plan will have to be produced along with the applications. After the said applications are filed, we propose to issue directions either to the local authority to constitute a team of officers or a team of architects to verify whether such buildings and units as in existence today are in conformity with the sanction plan. If some portions of the buildings are unauthorized and the same have been regularized, along with the applications, even the copies of the orders passed for regularization shall be produced. If such individual applications are filed, the same shall be listed on 9 September 2024. We make it clear that this order is applicable only to the buildings in 7 markets mentioned in para 2 of the order dated 18 December 23, the Judicial Committee. Now, the applicant here before my lords today is one of the buildings in one of the 7 markets. Now, it's not a coincidence, my lords, that after this order, where my lord said no question of just looking at the market as a whole and giving relief to everybody, only 3 applications were filed in 3 different markets. One of them is this. 2 other applications have already been disposed of. Just have a look at that order also, my lords. And these are, my lords, number of shops in these markets. Each market would have about 70, 100 shops easily. Each of them will have. So we are looking at massive number of shops. Now, please.
But the board itself can't give liberty to file an application.
That's correct. No, I'm only saying only 3 people have come forward. That's what.
So we'll consider only those who have come forward.
Correct. No, I'm only saying how today he's wanting to rely on the same Judicial Committee order is not justified. That's what I'm trying to say. It's only for that purpose I'm pointing out, my lords. Only for that purpose. Of course, he's entitled to file, my lords, and that will be considered on its own merits. I'm only saying only 3 people came, and they can't now rely again on the same Judicial Committee order where my lord said, no, it can't be done.
One bench.
We didn't allow it.
39. The next order I want to show is this, my lords. Page 32.
17,120.
The order of 17,125 of my lords. Starts at 32, my lords. Just have a look at page 39. Now please see 39. Para 17 and 18, 1 IA, like the present person. Counter affidavit filed by the MCD. My lords have that, my lords, para 17. Counter affidavit filed by the MCD.
Para 17.
17.
13.
Page 39.
IA number 20490.
It's at page 38.
Oh, I'm so sorry, my lords. Page 30. The internal page is 17, my lords. Actually, we are having it at 39. I'm not sure. I'm so sorry, my lords. It's showing 39 yet.
No, para 17 is there.
Luckily.
As long as para is same.
I'm so sorry, my lords. The counter affidavit filed by the MCD records that there is an excess area of 188 square meters. Affidavit filed by the MCD in terms of court's order of 9th December discloses that by the order dated so-and-so, application for compounding of the existing construction coverage has been rejected. We therefore dispose of these applications by granting liberty to the applicant to challenge the order dated 27th December. If the excess construction is either demolished or regularized, it will be open for the applicant to make an application for de-sealing. Whether the applicant is liable to pay penalty will be decided when such a fresh application is made. So left open. Issue of penalty is also left open.
So you will have to again come back to the court.
That's correct. The other person. The other applicant. Now, so far as this applicant is concerned, please come to order at page 42. 20th of May, 2025, the present IA. Now, please see
Page 42.
Page, my lords, 40. A5, my lords, 42 at 43, my lords. My lords have that. IA 203615. Pursuant to the order dated 9 December, by filing compliance report, applicant claims to have complied with the undertaking. We direct the concerned officers of the Municipal Corporation of Delhi to visit the premises and submit a report to this court on whether compliance has been made by the applicant with the undertaking recorded in para 8 of the order dated 9 December. After perusing the report of the MCD, prayer regarding de-sealing can be considered. While we pass this order, we must refer to the order passed on 22nd August 2024. In the said order, we had directed that those who want relief of de-sealing must apply to this court. It is therefore obvious that if such applications are made before the court, the same will be considered on its own merits without being influenced by orders passed by the Judicial Committee. This is what I wanted to highlight. Just only for that purpose.
So first we appoint the Judicial Committee. Ask them to do work. And then we say, no, whatever work they have done now.
No, only for this. Only for this. All other matters, my lord, the Judicial Committee passes orders. Anybody aggrieved comes. This was a case where, because, my lords, the Federation went and said All markets, everybody, irrespective of the type of allotment, irrespective of the type of use permitted, everybody will get relief. No payment of conversion charges. This entire case today, my lords, the issue is this, according to me, that he will be entitled to seek conversion. There is no problem in terms of the extant MPD. Question is whether they are liable to pay conversion charges or not. What the problem really lies with the Judicial Committee's order is this. Without looking at individual
How much are the conversion charges?
conversion charges in this case is about 85 lakhs according to them.
More than 1,000 crores, my lord, in all
So
the...
we are only concerned about one application.
Yeah, that's right. In this IA, it's
As Mr. Vishnu Kumar says that only 3 persons have come in spite of the orders passed by the court.
correct. That's right. Two issues I wanted to flag here, my lords. One is the larger issue of conversion charges. Conversion charges, in fact, the problem with the Judicial Committee order was this is where we made submissions before my lords, and my lords felt it can't be a broad brush like this. Everybody is just given relief without any payment at all. That is one. In fact, I'll point out one communication of DDA. My friend referred to one letter of a query made by an officer to DDA, where DDA said the problem then will be to refund monies to them. No, it's not a problem of refund. It's a problem of collection of money for providing infrastructure. I'll show that letter. That letter is there as part of the record. There is another larger problem, my lords. These are all places where there is a civic mess in the city. That's where, as Amicus, we want to highlight, my lords. There is so much of, my lords, issues of parking. Any market, my lords, can just have a verification, my lords. All the back lanes, the drainages are so, they're just choked, overflowing. So the place is, my lords, having so much problem. There is demand for electricity. There is so much of a pressure on the infrastructure. Sewage is a major concern. It is really in that context, my lords, these individual cases the MCD will handle, my lords. The larger problem is this. In fact, this was an issue which was raised before the Judicial Committee. When that order of 18th December was passed, we raised this issue. How can there be en masse consideration of such applications and everything is being permitted over a period of time? People start using these places for commercial use and no action is being taken. At some stage, my lords, there is a pullback, as it were. Thanks to my lords' orders passed by my lords and the monitoring committee, they have now been stopped. My lords will recall, these are not cases where the entire building is sealed. No, ground floor is permitted, which is commercial. Only the first floor and second floor, which is for residential, the conversion, you can't do without making an application, get it converted by paying conversion charges. Yeah. Now, that issue was raised before the Judicial Committee. Judicial Committee, unfortunately, says this is not part of our remit. The order by which we were constituted by the court really does not cover these larger aspects. Those are things which have to be argued before the Supreme Court, is what the Judicial Committee said, and left the issue. Therefore, as Amicus, we are concerned only with two things. One, the need to look at, my lords, the master plan and also the relevant notifications issued by DDA to see conversion charges and how much is to be paid. Look at conversion charges, under what circumstances they are payable, and if they are payable, how much is to be paid. Second, my lords, is to look at the issue from the larger perspective of, my lords, how these developments are completely, my lords, out of sync with the carrying capacity of the infrastructure in the city. I am looking, my lords, there is no fire safety. I am looking at
Whether this blame should not go on the planning authority?
No, therefore, planning authority.
If the planning authority is, like, we in the Chandigarh,
Yes.
we have prohibited the apartmentalization of the plots which were.
Yes.
But here, every plot is now permitted to be constructed.
No, that's right, my lords, but with the rider. There's one important letter of DDA, my lords, which I have to show to my lords. 2018, these conversion charges and the rates at which they are to be done was brought in. Now, very important, my lords, in my compilation itself, just come to, my lords, show me that letter. It is, my lords, at page, there is an IA which my lords have called for yesterday. That is IA 32418, which was the IA filed by the MCD. Just look at page 333, my lords. The rationale behind these conversion charges. Just have a look at that, my lords. 32418 IA. Page 333.
MCD only looks at finances without, therefore this problem.
Do my lords have that 333, my lords,
Very nice, very nice.
in the main MCDIA?
Yes.
It's a letter of 27/11/2018 by the DDA, because they are the planning authority for Delhi, my lords will recall. Now, please note right at the beginning, this has reference to your DO letter so-and-so of 25/10/2018, wherein clarifications have been sought with respect to payment of conversion charges from residential to commercial for upper floors and basement. In the case of shop plot stroke CSC stroke LSC stroke shop cum residence, latter designated as LSC, which are governed as per the standard plans. This is the letter my friend read out from his convenience completion, where, my lords, the letter sought clarification whether conversion charges are payable, and in case what is collected, conversion charges are not payable, money will have to be returned. For that, DDA gives an answer saying no question of return of money. Which are the cases which are covered? Their case also will be covered by this. That's why this letter is important, my lords. And also, what is to be done with the money which is collected by way of providing infrastructure? What fell from my lord the Chief Justice, where my lord said in Chandigarh, where my lord said no development. Here, they are permitting development but saying we'll collect conversion charges for providing infrastructure. That's the drift of this letter, my lord. Just have a look at that, my lord. So they refer to the letter which seeks the clarification. It has been mentioned in the letter that as per MPD 2021, such plots and markets should be governed as per the standard plans.
You are reading where?
I'm reading from the beginning of the letter, my lord.
This is a reference to.
This is the reference to, after that, the second sentence.
Yes.
Second sentence. It has been mentioned in the letter. My lord's got that. It's been mentioned in the letter that as per MPD 2021, such plots and markets should be governed as per the standard plans, and the conversion charges are payable for conversion of upper floors for commercial purpose. Subsequently, another DO letter dated so-and-so, dated 26/10 has been received, wherein the above issues have been reiterated and similar clarifications have been sought regarding payment of conversion charges. It has further been mentioned that part payment of used conversion charges for upper floors in the shop plots has been received in a number of cases in LSCs like Defence Colony Market, Sundarnagar Market, M Block, GK2 Market, GK1 Market, Green Park, etc., my lords. Any interpretation, please note this, my lords, any interpretation of clause 5.6.3c of the notification of 21/6/2018 in isolation with the rest of the clauses of the said notification would lead to a loss to the tune amounting to 1,000 crores, which are otherwise required for creation of multi-level parking, toilets, and related augmentation of infrastructure emanating out of the enhanced FAR being provided in these markets. The points raised in the aforementioned DO letters have been discussed and deliberated at different fora. It is realized that there has been an oversight in the interpretation of the provision made under 5.6.3c of notification of 26/6/2018, which has led to the misinterpretation of the earlier issued clarification dated 14/9/18 and 17/10/18 by the DDA to the concerned municipal corporations. Such interpretation may lead to unintended, please note this, my lord, may lead to unintended windfall gains to the property holders in the erstwhile shop plots built as per the standard plan, wherein ground floor was commercial and upper floors were residential. Such clarification would also lead to huge loss of revenue to the municipal corporations, and that could deprive them from taking up infrastructure improvement projects like parking, pathways, utilities, etc. This is also quite clear from the provisions under 6.4 of the notification of 21/6/2018. It is noticed that in shop cum residence plot or shop complex declared as LSC, CSC, where standard plan was used for the upper floors was intended to be residential. However, in other such shop plot complexes which are not made but as per the standard plan, the total complex was commercial development. It is further noted that the practice so far in vogue had been that whenever the upper floors in shop complexes with standard plan were converted, the same was done after payment of conversion charges as have been approved by the government. In view of the above, after due consideration, it has been decided to annul the clarification issued by DDA by the letters dated 14/9/18 and 17/10/18 on the subject, so that there is no unintended windfall gains to the property owners in the shop cum residence complexes of standard plans. Accordingly, the relevant paras in the earlier issued letters dated so-and-so on the subject matter stand withdrawn. Based on the above and the provisions given in subclause 6.3.b and d, read along with subclause 5.6.3c of the notification of 18, it is hereby clarified that for shop cum residence plot complex declared as LSC, CSC under MPD or zonal development plan, which were built as per standard plan, conversion charges as notified by the government will be levied for conversion of upper floor from residential use to the commercial use. For all the LSCs, CSCs which are having sanctioned plan as commercial for upper floors, no conversion charges will be levied for the upper floors. Very clear, my lords. And
According to you, there, the plan is ground floor commercial and the first upper two floors are residential.
residential. One more thing, my lords, they say in their IA, wrongly sanctioned by the MCD as upper floor being residential. Everybody knows, my lords, when you make an application for sanction, you give the plan. The applicant who makes the application has to give the plan. It's not that, my lords, MCD with its architect will make a plan, decide where your bedroom will be, where your kitchen will be, where your amenities will be. Just now, in fact, in my compilation, I've given the standard format which is to be followed for making an application for sanction of plan. Page 1 of my compilation, which I just gave. Page 1. Because,
They show it as a bedroom. They show it as a bedroom.
yeah, that's what I showed.
Checklist.
Idea.
See my age.
Yeah.
They get it sanctioned as a bedroom and then they say sanctioned.
Commercial. Just see page 1, my lords. This is, my lords, from the website of MCD that I took out. Checklists of documents, what I just gave to my lords now. That's right. Page 1 of that. After the index, my lords. Checklist of documents required to be submitted through online mode along with common application form. CAF to be filled up online along with the form for NOCs from the external NOC agencies. Following documents shall be submitted online along with the CAF, that is common application form for sanction of the building plans. Drawings and statements prepared in AutoCAD format, WD so and so format, and PDF wherever required along with the part layout plan. This is the first document they have to give. Today, it'll be a little far-fetched to say they wrongly gave it for ground floor being commercial and upper two floors being residential. That is the way it was, my lords. The larger point in this is this, my lords. There are two types of local shopping centers and complexes in Delhi. One, my lords, where they are from the beginning designated as local commercial centers, where for the entire complex it is, my lords, an integrated plan. Individual cases are not gone into. The whole thing is commercial. Then over a period of time, my lords, markets have developed. This is both due to, my lords, necessities of life. We must accept that reality. Livelihood issues are there. People want to use commercial because that's more lucrative than residential. That's one. Two, coupled with the inaction of the authorities. Over a period of time, markets have grown. They have definitely grown. So some scheme has been brought in by which they say, my lords, any later designated LSCs, where the use is, my lords, mixed land use, both commercial and residential, there is a scheme which has been brought in. Now just have a look at that, my lords. This is under the MPD itself. A2, my lords, in the same compilation, the relevant part, page 9. We have just given the relevant part from the master plan, my lords. I've given the first page. Just have a look at page 10, 5.6. Community Center, CC. My lords have that. LSC, Local Shopping Center, Convenient Shopping Center. Community centers should be considered shopping and business centers catering to the needs of the population at the community level. These centers may have retail shopping, commercial and government offices, local body or public sector undertaking offices, cinemas, cineplexes, hotels, restaurants, etc., etc. It goes on, my lords. Now, please see 5.6.3. Shop cum residence complexes. My lords have that. Shop cum residence complexes, within brackets, shop cum residence plots, stroke shop plots. My lords, note that. Now, the documents what they have filed of 1957, 1981, 87 and all that, that will mention it as a shop. That is because, my lords, only one floor was there. Single story shop. Today we are looking at further developments above. Now here they encompass within them, this regulation encompasses within itself shop cum residence plots and shop plots. That's important, my lords. Shop plots later designated as convenience center, LSC, CSC is already earmarked and shown in the respective zonal development plan. My lords will recall the judicial committee order and my friend's submissions where they are designated in the local zonal development plan areas. Shall be allowed to continue with the activities permissible in the local shopping center with the following conditions. FAR of such plot shall be prescribed. Yeah.
Just taking the portion of the division from the order where they say annual implement infrastructure issues, and it quickly doesn't quickly take to that. So I'm saying infrastructure is a problem. What if it is a annual implement?
That's not need.
I want to show that.
100.
No, I'll just continue, my lords. A FAR of such plot shall be as prescribed for respective size of the residential plotted development or lease deed or conveyance deed or sale deed or allotment conditions, whichever is more. However, in case total FAR in the existing building is exceeding the permissible FAR on the plots of size above 100 square meters and up to 250 square meters. So we are not falling under this. This is less than 100 square meters. But FAR I'm reading for one important reason. Such excess FAR up to maximum 350 FAR shall be permitted subject to payment of penalty charges as prescribed with the approval of the government. B. Payment of use conversion charges from residential to commercial shall be applicable as prescribed with the approval of the government. This is the important point, my lords, where there is a point of distinction. What the applicant is today saying is, no, there is no need. It is always treated as commercial. Then I don't need to pay. This is not conversion from residential to commercial. This is the long and short of what they are saying. They want to say C. Please have a look at that. LSCs, CSCs and shop plots which are already under commercial use zone are not liable to pay any conversion charges. There the difference is this, my lords. This is not a commercial use zone. This is a later designated LSC. Where shop cum residence is a mixed land use, where, my lords, therefore, any conversion of residential area which is in the upper floors has to be on payment of conversion charges. This is really the long and short of the issue, my lords. The problem which came with the judicial committee order, where my lord said ultimately no, it can't be done like this, is that you have to look at individual cases. There are, my lords, cases in each of these later designated LSCs where there is a single floor shop. There is also, my lords, a shop cum residence which has 2 floors. Even there, the original allotment itself. In fact, in one of the IAs in Defence Colony, my lords called upon us to enumerate and look at each of the allotment letters of individual cases. No question of broad brush saying everything will be covered either by this or covered by that. They want to take advantage of that, which is why my lord said, no, you can't rely on the judicial committee order and say, no, I will get this order.
Mr. Vasudev is not exposing the cause of everyone. I think you are restricting your claim to yourself.
Yeah, that's right. But he is relying on the committee order. He's saying the committee order is in our favor. All of us are in the local shopping complexes. We are entitled to the benefit of no payment of conversion charges. Everything will have to be accepted. That's why, my lords, this problem is coming. One more thing. Therefore, they want to rely upon C, my lords. That it is mixed land use. And also, please have a look at 5.6.4 also, my lords, in the same page. Other existing shop cum residence plots shall also be allowed to continue with original permitted use. With the FAR of the residential plotted development, the upper floors can be converted to commercial use after paying the applicable charges. It's really twofold here, my lords. One, they want FAR of residential because that's more. But they are saying no conversion charges. It's really becoming like a double whammy.
So FAR for residential?
More than commercial. Much more. 3.5, it is more than 100 square meters. I read that 3.5. 350. So 3.5 FAR If it is more than 100 square meters, up to 250 square meters. If it's less than 100, it's a little lesser, 2.5 or 2.25, they'll be able to bear me.
So what is the FAR that they have taken?
Your calculation mentions it.
But approximately around first and second is 350. If it was only commercial, it would have been 100.
It would have been only 100, one FAR. One FAR. This is where, my lords, the whole thing gets stuck. I will get residential FAR benefit, but I will not pay conversion charges because it's already a commercial area. In fact, my lords, that it is not commercial will be evident also from one more thing, my lords. My lords, see at page 12 the mixed use regulations. The policy acknowledges the need for permitting use of land for purposes other than that for which it was originally envisaged and lays down the conditions under which this may be applied in different situations. The general procedure to be followed for implementation of the said policy and mitigating measures to be taken to counter the effect of such unintended use in such areas are also described. I will not trouble my lords with all the nitty-gritty of all this, my lords. Just now it may not be relevant. 15.2.1 alone, my lords. Mixed use in residential areas. Same page. Same page, page 12. Page 12. 15.2 mixed use in residential areas. 15.2.1 differentiated approach. The need for differentiated approach to mixed use policy arises from the fact that Delhi, being the country's capital and an important center of economic activity, has a large diversity in the typology of residential areas. Apart from the residential colonies built as part of Lutyens Delhi, as well as through the process of planned development undertaken by the Development Authority, there are authorized residential areas in the walled city, special areas and urban villages. Other planned areas include resettlement colonies. Please note this, my lords, resettlement colonies, very important. I'll just pause for a minute. There are all these resettlement colonies, many of them, Defense Colony, Lajpat Nagar, all of them were areas where in the 50s, when people came in from Punjab and other places.
Oh, Rajput Colony.
Sorry, my lord.
The Defense Colony was for
Armed persons. Armed persons, there are also these people where
Defense Colony had buildings in three classes, A, B, and C.
Yeah, but they have to put the...
essentially.
Rajput Nagar has been for rehabilitation.
Exactly. Where, my lords, ground floor you can have commercial by which you can eke out a living. Upper floor will be for house. That's how all these were allotted. Many of these are those rehabilitation colonies. I'll show the list of rehabilitation colonies also where New Rajendra Nagar is noted in the master plan as an annexure. Ground floor for commercial, upper floor for residential. But over a period of time, the planning authority said, yes, we will permit, but on ABCD conditions. Now, just to see further, my lords, resettlement colonies and pre-Delhi Development Act colonies. I'm reading, continuing in 15.2.1, my lords, the same where I was reading. Special areas and urban villages, other planned areas, line about 4 or 5 from the bottom. Other planned areas, my lords, get that, my lords, include resettlement colonies and pre-Delhi Development Act colonies, including post-partition rehabilitation colonies and pre-1962 residential colonies as per list given in Annexure 1. There are also regularized unauthorized colonies as well as slums and juggi-jhopdi clusters in various parts of Delhi. Then, my lords can go to the annexure, which will be immediately relevant. Now, please see Annexure 15 at page 15. It's at page 14, my lords, I'm sorry. List of page 14, lords. List of pre-1962 built up residential and rehabilitation colonies. Just see item 32 in the right hand side column, my lords. New Rajendra Nagar. The market my friend is talking about is here. The concerned shop that he is having, my lords, is here. These are all residential and rehabilitation colonies initially. That's how, my lords, the allotment comes of a shop being given a single floor. Then you want to go up further. 2005, he makes the application when he wants to rebuild. When he wants to rebuild, he consciously makes the application for ground being commercial, upper being residential, which is what is sanctioned. Then they have a turnaround. People get together. There is this provision for local shopping complexes which are planned originally as shopping complexes where the entire thing has an integrated plan. They say, no, we must get the benefit of it. And saying that, no, we are not liable to pay any kind of conversion charges. That's where the problem occurs, my lords. Then one more thing I wanted to highlight, my lords. This kind of a reliance on this stand this is really the third bite now. Not even the proverbial second bite, my lords. 2019, much before the constitution of the Judicial Committee, IA was filed by the LSE's Federation before my lords, raising similar claims. That was dismissed by my lords. That order I've given my lords at page. It's not here in this. It's been a year. I'm so sorry, my lords, that IA of MCD, which I read from. You want to show it. There is an IA file on substantially the same grounds, claiming that no liability to pay conversion charges, etc., because we are designated LSCs.
I think should I point out, right?
I'll just finish in 2 minutes. 2 minutes. Just in my index, my lords, I have pointed that out. Just have a look at that, my lords. My friend will give the order itself. Just come to my index, my lords. The second page of the index. My lords have that item 14 and 15. Earlier IA filed by LSC dismissed on merits. My lords have that. Where?
Serial number?
Serial number 14 and 15, my lords.
There are only 13.
I'm so sorry. I'm so sorry, my lords.
Is it IA number 67784?
That's correct.
It is 9 and 10.
Oh, 9.
That's on my bill.
What master?
So
Here one call right here.
I'm so sorry. 67784 and 58021 of 2019. Page numbers are correct. That's from the IA. The page numbers of the IA is right, my lords.
Second page, serial number 13, 14, 15.
15, but theirs it says 9 and 10.
That's fine.
Page 211 in the IA, my lords, of MCD IA, it's there. The prayer is there. In fact, the drift of the IA will be seen, my lords. Then the order which is passed by my lords is at page 458 of that same IA. Page 458 of that IA.
Yeah, they should.
There are 2 other things which I want to highlight, my lords. So this was the first instance. Then comes the proceedings before the Judicial Committee, where again the LSCs argued, accepted. My lords then said, no, we'll look at only individual IAs. And a specific order in this IA itself, where my lord said, don't rely on the Judicial Committee order. Whatever documents you have filed, you rely on it. But not the reasoning in the order on merits. Then one more thing, my lords. My friend spoke about how payments having been made. All payments have been made, only conversion remains. How can they stop? They are relying upon payment of 1,23,000 rupees. There's a receipt which they have filed. That receipt, my lords, will be found at page 64 of the convenience compilation which Mr. Vasudev filed.
So tell him this. So you
I'll give it. Yeah. It's item 13 in that index, my lords, which we have just given, the corrected index. More copy, Papa. Do you have another copy of the index? दे दो इधर. Convenience compilation, my lords. Page 64.
Yes.
It was given on Thursday. Even at the other Thursday.
They had given.
They had given it on Thursday. Yes.
I think so. They brought it.
1,20,625.
That's right. That's right. Now this is for additional FAR. Please see that, my lords. For conversion. This is, my lords, for the basement additional construction. And MCD is pointing this out, my lords, in their affidavit. I've given the page reference of that also, my lords. My lord, see right at the top in this, additional FAR charges.
extra, all it would be. So that's the.
Just see right at the top, my lord, it says additional FAR charges for basement. My lord, see that. In this, additional FAR charges basement. 69 square meters, etc. That calculation, I am sure they will place it, my lords. In their affidavit, they have given how the calculation is taking place, what is the actual construction, so how much is the conversion charge, etc. There, my lords will find this figure of 69.5 for the basement, which is the basement use. That also they want to use for commercial. So it's really like 3 or 4 floors. Basement, ground, first and second, right? Is there a third also? So this is the receipt.
Just see the description.
Yes, my lord.
Particulars.
Yes, my lord.
Says registration charges, annual mixed-use charges, parking charges, and extra FAR.
That's right. Please see that that is ticked. What is ticked is only this.
Extra FAR.
Okay. That's right, my lords. The last one, and please correlate this with the upper portion.
Yes, additional FAR charges.
Additional FAR charges for. That's why, my lords. In fact, the next item in that index of mine, I have pointed out the this one, the additional affidavit of MCD, where they are mentioning this, my lords. In the same index, the corrected index which I have given, additional affidavit of 19/7/25 filed by MCD.
We have 2 copies.
I have given only 1 copy. I'll just give the second copy, my lords. I'm so sorry.
We shared 1 copy which we had.
Pay item 12, my lords. Item 12. 13 is this proof of payment which I read out. My apologies, my lord, that I have given.
Read from 1. Otherwise, for something we have to look at 1 and then.
I know, yeah, that's true. That's
You have it in the earlier one also.
Yes, there.
There is it. There is that.
Page 64.
actually, my lords, the items are the same. The numbering, there's a confusion. My lords. That's the only problem. It's an additional, it's under the heading payment made for additional FAR for basement.
Yes. Rough addition.
Payment made for additional FAR for basement is not towards conversion charges.
Okay.
There, my lords, the MCD affidavit I have pointed out, where they have mentioned this. And then the receipt also I have pointed out. I mentioned about the earlier IA of the LSC, and then the earlier orders of my lords is the last item in that index. Just 2 other things I want to highlight, my lords. The conversion of upper floors from residential, that's the previous item in the index, my lords, in my index. Conversion of upper floors from residential to commercial is subject to payment of conversion charges. All these notifications are there. Then the letter of DDA, my lords, of 27/11/2018, I have already read out. Page 333 of the IA of MCD. What this payment is, I have read that out. One last thing, my lords, is just see the previous item. The property of the applicant would be covered with the regulations for latter designated LSC as specifically provided by DDA and MPD 21. This is consistent with the land use, which is mixed land use, that is ground floor being commercial and upper floor being residential. Now, please see, this I've read out, 5.6.3b. That's really the heart of it. Read with Annexure 50. And then I pointed out, my lords, how their documents they are relying upon, it shows shop, single floor. In fact, page 39 of the convenience day, I pointed out, my lords. It says house property. 2005, when the application is made, commercial with residential. This is how, my lords, the issue will have to pans out and will that be looked at. The conversion charges, my lords, they are really here to justify on what basis it's being claimed. These are broad things. Just one last thing. I mentioned about how there's a problem because of all this without payment of conversion charges. This issue was highlighted before the Judicial Committee. Just come to, my lords, his IA, the main IA by my friend. The order of the Judicial Committee, my lords, it starts at page
368, 315.
315, yeah.
03.
315
This page.
at 358, my lords. The main IA, my lords.
Page
358. Page para 91. Shri so-and-so, my friend Mr. Rao was there. Learned Amicus made an attempt to question the very concept of mixed land use introduced in MPD 2021 and opened submissions by arguing that the notifications amending MPD 2021 permitting mixed land use was ultra-vires the Delhi Development Act, which had at its heart the concept of planned development of Delhi and highlighted the parking issues and the problems created in residential areas by notifying mixed land use streets. As a consequence of mixed land use permitted after charging conversion charges with no adequate parking space carved out, Learned Amicus proceeded to submit that with cars parked on the pavements and roads wherever the roads were notified as mixed land use, there were traffic jams resulting in carbon emission, thereby polluting the air of Delhi, which Learned Amicus stated was rated as severe or very severe for nearly 100 days in Delhi. Fundamental right of citizens of Delhi to breathe fresh air was brazenly violated. Committee did not permit Amicus to expand its submissions for the reason that the present committee has been constituted by the Honorable Supreme Court with a limited jurisdiction to decide the validity of sealing actions taken by the municipal authorities under the directions of the monitoring committee constituted by the Honorable Supreme Court, and the present committee is not vested in the jurisdiction to test the validity of any law. Committee is not dealing with the said submissions. That's how, my lords, they say we are not going to go into all this. And I pointed out, my lords, the larger issue of pressure on the infrastructure. The carrying capacity is simply not there. You cannot have hundreds of shops in places where the infrastructure is not there, and some provision is being designed by the authority to collect these charges. Purportedly for putting it to use of providing infrastructure. We'll have to hope that they'll do it. But then to take an extreme stand saying, no, I'm not liable to pay any charges, perhaps, my lords, may not be in order. That's really what I wanted to highlight, my lords, for my lords' consideration. I'm obliged.
Yeah, please.
So,
Lordship may kindly take my IA, my lord, 32418, my lord. 32418. P2418, my lord, page 187 straight away. 187 of page of this IA, my lord.
Page?
187.
This is the MCD appeal where we are not parties.
187.
This
No, I'm just relying on the document.
is the appeal filed by the municipal corporation against the judgment of the JC. We are not parties to it.
No, but then you were parties before the judicial committee.
Before the JC, but we have not been made parties in this IA. I do not know what it is.
No, my learned friend appeared before the JC in this very matter.
JC, yes.
Yes,
You
you
are
appeared.
filing something in which I'm not a party.
Anyway, Lordship may kindly come to page 187. I'm just relying on some
Have
court orders.
you at least included those associations as party respondents?
They are all parties, my lord. The associations are parties. Mr. Vasudev himself appeared, my lord, before the judicial committee
For the associations. Now he has come up, my lord, and appearing before this individual.
But I don't know what you pleaded here.
187, my lord, clause 5.6.3b, which is, my lord, really the bone of contention. I'll just read it, my lord. Shop cum residence complexes, shop cum residence plots, shop plots, later designated, your lordship has already noted this, later designated as CC, local shopping center, CSC, as already earmarked shown in the respective zonal development plans, sub-zonal plans, or to be declared notified, shall be allowed to continue. They were not earlier allowed to continue because, my lord, they were allotted and allowed to continue on commercial activity only in ground floor, but they illegally expanded the, my lord, business activity to the first and second floor. What the master plan says is shall be allowed to continue with the activities permissible in the local shopping center with the following conditions. B, payment of conversion charges from residential to commercial shall be applicable as prescribed with the approval of the government. So you are illegally carrying on commercial on first, second, etc. You will be allowed to continue subject to payment of these conversion charges. Now the letter that Milord, the learned Amicus had pointed out, Your Lordship may just come to this very volume, Milord, 333 and 334. It is important to, Milord, highlight what the DDA is, Milord, the author of the master plan. DDA, Milord, is the author of the master plan, and Milord, it is notified by the central government, Ministry of Urban Affairs. Now, Milord, DDA's interpretation of this clause is at page 334, last paragraph. Based on the above, the provisions given in the subclause 5.6.b, which I just read out, is hereby clarified as under Roman 1 for shop-cum residence, which is, Milord, the case here, complex declared as LSC, CSC, that is local shopping center, etc., under master plan, which were built as per standard plan, conversion charges as notified by government will be levied for conversion of upper floor from residential use for commercial use. Then for all the LSCs, CSCs which are having sanction planned as commercial, for upper floors also. So there are some, Milord, designated local shopping centers where the entire market plan was sanctioned one at a time, Milord, at one go. For the entire market, all floors, Milord, were commercial. Those are markets are also there. They will not be liable to pay. But whatever was shop-cum residence, Milord, plan sanctioned as shop and then residence will be liable to pay conversion charges. This, Milord, was challenged by, Milord, by the shopkeepers and the markets, individuals as well as the association by way of writ petitions in the Delhi High Court. Delhi High Court said, Milord, that this matter is pending before your lordships. They declined to interfere. Thereafter, Milord, an IA was filed, Milord, which fines mentioned, your lordship may kindly see, starts at page 221 of this very volume. 221. And the rationale, the very letter which I read out, Milord, very clarification of the DDA, which says that you have to pay conversion charges for upper floor, was challenged. And the rationale, Milord, 221, your lordship may kindly turn to 228. I am not, Milord, troubling my lords. 20 pages has been, Milord, written. 220, lordship may just note the pages. 228 to 248. All these, Milord, market associations have argued and laid down the rationale that conversion charges, why conversion charges should not be levied on the upper floor. And Milord, kindly see the prayer at page 252 at prayer B. Declared that the impugned letter, what I read out, Milord, was 27/11/2018 issued by the DDA is illegal or void. So the prayer was this declaration, clarification by the DDA that conversion charges has to be paid, be declared void. Now your lordships, Milord, at page 456, 456, at 458. That time, Milord, the matter was being heard by Justice Arun Mishra. This matter was, Milord, taken up in detail. 458, your lordship may kindly see at serial number 5. These are applications for intervention, clarification on behalf of the Local Shopping Center Federation, Delhi. Applications are dismissed. So therefore, Milord, this issue whether, Milord, conversion charges are payable or not has been finally decided by my lords. This is, Milord, point number 1.
Finally decided by?
By your lordships. Because they've said that by this clarification by the DDA, no, Milord, conversion charges are payable on these shop-cum residences. Milord, those 20 pages I have not read out. They give all the rationale, Milord, why shop-cum residences should be, Milord, treated as par with.
Yes, then their interventions are not permitted. So,
and also, Milord, it was dismissed on merits. The application was dismissed for direction.
can you say that?
It was dismissed, Milord. I was myself there, Milord. I was myself there. It was argued for, Milord, a few days, and it by this order.
Few days?
Yes, Milord. Went on for some time.
Just like a SLP this month.
So, my lord, they have been. So, my lord, this issue of payment of conversion charges, in fact, there is another set of writ petitions which I am told have again been filed by some other shopkeepers individually as well as by another association which is today pending before the High Court. My lord, they are trying to, my lord, make several attempts to get some order somewhere, my lord, just in case. After your lordship have finally decided that conversion charges are payable and, my lord, DDS, there's no clarification required. Very clear, my lord, DDS clarification that conversion charges are paid. Now, your lordship may kindly see, my lord, just 3 documents. I'll just hand over a compilation. Just 3. In fact, I'll just trouble my lords with 2 documents, my lord, quickly. In relation to my learned friends, I just give them a moment.
Sir, second bedroom.
Lordship may kindly come to, my lord, page 1, the sanction plan. The second, my lord, there is the ground floor, my lord. And this is, my lord, filed by them in 2005. So the original allotment, whatever was the structure, was demolished. After this sanction plan, my lord, a new building was constructed as per this sanction plan. Kindly see, my lord. It clearly says shop in the ground floor. There is no difficulty.
Where do you?
My lord, I'm so sorry. My lord, my lord, on the left-hand side, bottom, first is basement floor plan and thereafter, my lord, ground floor plan. Basement, my lord, there's nothing here. Kindly see the ground floor plan, it says shop. Lordship has it, my lord?
Yes.
Then, my lord, lordship may kindly come to the first floor. There is a bedroom.
Kitchen.
There is a kitchen. There is a dining room. This is his own sanction plan.
Same on the second floor.
Same on the second floor. Kitchen, lobby, bedroom, toilets, etc. So the entire, my lord, whatever was allotted was demolished. Fresh sanction plan was applied for. Sanction plan was sanctioned and the building was constructed.
Page 179 of his IAM note, same document, page 179.
Then, my lord, of the same compilation, your lordship may kindly turn to page 5. Page 5, the picture of the building as it stands today. Lordship has, my lord, page 5?
Yes.
Yes. It's a little unwieldy, my lord. It's a little unwieldy. Nowadays, my lord, it's all electronic.
The lighter vein, my lord, my friend says, in the lighter vein, my friend says this is a little unwieldy. I was impelled to think anything with MCD is unwieldy.
Now, my lords may kindly turn to page 5. Now, my lord, on first blush, what does this picture, my lord, appear? That there are 2 units in the ground floor,
Yes.
and there is 1 unit in the first, 1 unit in the second. What actually is the position, my lord, I was instructed yesterday that the unit, my lord, is only this Bon Thames Cafe. He has, my lord, amalgamated the next plot, which is, my lord, Pluto Pizza, and made it into one so that the first and second floor look like one. Actually, there are two. It should they are vertically divided. Actually, these are two plots. He has illegally amalgamated the two plots. The ground floor he has kept separate. First and second he has amalgamated. All belong illegally.
The second plot belongs to who?
Somebody else, the next shop, the adjoining shop. He must have entered into some arrangement or not financial or otherwise. Illegally. No permission from the corporation. So, my lord, when we, my lord, I am again not troubling. I have annexed, your lordship may just make a note. I'll just take you trouble, my lords, with the relevant pages. But your lordship may kindly note, my lord, the orders of 14.8 and 10.9 for the sake of convenience.
Yes, conversion charges include from.
So not only, my lord, is the amalgamation illegal, he has encroached upon government land. The staircase, my lord, is... They have not paid...
No. We are just asking you.
They have not.
They pay conversion charges. Is this permissible, this amalgamation?
My lord, then in addition, amalgamation is not allowed.
Amalgamation is not allowed.
Is of plots are not allowed. So that is also illegal. This entire, my lord, exercise... Not only that, they have encroached on government land, public land, which your lordships in this case has deprecated. And one of the mandates to the, my lord, to the corporation and the monitoring committees, my lord, just get all encroachers out of government land, because, my lord, valuable government land is being encroached. Here the staircase and all is all encroaching on government land. We, my lord, send them notices for a joint inspection. Just one second. No, I'm sorry. Please don't interrupt. I asked them for a joint inspection, not once, not thrice, but 3 times. He refuses to come. He refuses to, my lord, allow me to take photographs, refuses to inspect the property from inside, my lord, inspect his documents. He does not give anything. So apart from illegal construction, encroachment of government land, amalgamation, he, my lord, illegally uses. This entire use also of the first and second floor was also illegal. But now, my lord, to be fair, the government by this notification of 2018 in the master plan has said, very well, my lord, market after market has illegally converted. You pay the money, convert it so that we can utilize that money for sewage, parking. My lord, kindly see the number of cars which will come to these shops. Originally, if the resident, if the owner was on the first and second floor, he would have had 1 car, and my lord, whoever was coming to the ground floor shopping, my lord, for shopping would have come in their own cars or vehicles. Today, all 3 floors, kindly imagine, my lord, the number of customers which is coming to just one plot. My lord, forget about the entire market. Which is why the government, my lord, has introduced this concept of conversion charges for, my lord, for creating the infrastructure for not only parking, sewage, electricity, solid waste management, etc., etc. And in his IA, my lord, he has tried to mislead your lordships by showing only one shop. I'm not, my lord, troubling my lords with the nitty-gritties of the facts as to how many meters has been, my lord, encroached, etc. My lord, all that is also there. Now, if your lordship may kindly come back to, my lord, my affidavit, my IA, at page, my lord, 181. Because it is necessary, my lord, your lordships are hearing this matter for the first time. It has a checkered history. And a little bit of background, my lord, may be helpful for your lordships to decide this matter. And that, my lord, we have set out at page 181. My lord, at para 16 straight away. My lord, I'll just read whatever is necessary, my lord, and not take your lordship's time any further. Para 16, the matter concerns the user of land in Delhi. Statutorily, the determination of use of land in Delhi is planned by the Delhi Development Authority constituted under the Delhi Development Act. DDA, my lord, is the planning authority. We the planning authority. As per the said act, the manner of use of land is determined at various levels, from macro to micro, by the master plan for Delhi, hereinafter referred to as MPD, which is promulgated and revised regularly. The development of different areas of Delhi is a planned activity carried out broadly at 3 levels. First level, my lord, is the master plan. As per section 7 of the DDA Act, it should read, my lord, DDA Act. 7 of the DDA Act, which is marked as Annexure 7. All, my lord, the annexures are there. I will not, my lord, trouble my lords by going into the annexures. Each and every annexure which is marked here, my lord, is part of this application for your lordship's convenience. The DDA is required to carry out a survey and thereafter shall prepare a master plan for Delhi to define and indicate the various zones and the manner in which each zone is to be used, which shall serve as a basic pattern of framework within which ZDPs, ZDP, my lord, is zonal development plans, which I'll come to later. So there is a master plan. Delhi is one. Delhi is divided into various zones. So there is one master plan for Delhi. Then there are various zonal development plans for each zone.
How much time will it take?
Will not, within half an hour I'll finish. I'll just read this. This is a little important. I can.
Yes, we know, because this is likely to have a bearing on all.
It will.
All
This
of
is
this
very important, my lord. We can continue, my lord, on the next day.
No. We'll finish it. We'll give you half an hour and then 15 minutes.
Yes.
Sir.
Yes.
So,
Yes.
We will board discharge.
Yes.
At least once for all, some issues will get settled.
Yes. In fact, my lord, as I said, my lord, it's not a question of one shop only.
Yes.
This will be used as a precedent, my lord, by every 100 shops in this market, all the 7 markets in Delhi who are before my lords, and all the other markets in Delhi, my lord, which according to us, my lord, the value, my lord, is more than 1,000 crores of these conversion charges, which have not been illegally paid. Therefore, it is important. Otherwise, my lord, I am just troubling my lords with whatever is only necessary.
We will conclude within half an hour.
Yes. I will, my lord, not even trouble my lords with reading the annexures. I will just indicate the page numbers. That's all.
I mean, discharge is the board. Board is
Board discharge, yes.
So the contempt matter at item 35, can a date be given because they've not complied at all with the order of this court? Twice this court ordered regularization, which this court had already ordered, and now